Welcome to this explainer. We are jumping right into a fascinating administrative law case today that proves, without a shadow of a doubt, just how wild neighborhood disputes can actually get. If you've ever lived in a community with a homeowners association, you already know that things can occasionally get a little tense over, say, paint colors or fence heights. But the case we're looking at today, straight out of a Sedona, Arizona subdivision called Casa Contenta, takes HOA drama to a whole new level. Picture this for a second. You wake up, look out the window, and find your homeowners association actively landscaping what you completely thought was your own private property. And we're not just talking about planting a couple of extra flowers here. They are bringing in loads of crushed red rock to cover the ground right in front of your house, completely against your explicit wishes. Would you know what to do? More importantly, would you know if they actually had the legal right to do it in the first place? Well, that is exactly the situation homeowner Chris Gelb found herself in.
To figure out how this all went down, here's our agenda for today. First, we'll cover the red rock dispute. Second, the discrimination claim. Third, drawing the property lines. Fourth, the judge's verdict. And finally, who pays the bill.
All right, let's kick things off with Section 1, the red rock dispute, a landscaping war.
Let's lay out the facts chronologically. Things actually started out pretty peacefully back in 2004. The homeowner submitted her architectural and landscape plans and got preliminary approval to start building her house. But fast forward to the final stages of construction in October 2006, and tensions completely boiled over. The HOA basically told the homeowner she needed to apply a ground cover of crushed red rock to get her final approval. When she objected, the HOA didn't just issue a fine. No, they actually went ahead and applied the crushed red rock themselves, entirely at their own expense. This super brazen landscaping move led the furious homeowner to file a formal legal petition against the HOA in March 2008.
Moving right along to Section 2, the discrimination claim. The legal argument. So, what exactly were the formal charges she brought against the HOA? You'd probably guess trespassing or property damage, right? But nope, she took a totally different legal route. Her entire case hinged on this one exact sentence from the community's governing documents. It literally states that restrictions must be applied to all owners without discrimination. Basically, she claimed the HOA was playing favorites, specifically targeting her property while letting everyone else off the hook.
What's really interesting here is just how straightforward her argument is. It goes like this. First, the HOA forced this crushed red rock onto the front of her specific home. Second, it was an undeniable fact that there were other homes in the community that didn't have this red rock installed yet. Therefore, her conclusion was that the HOA was actively discriminating against her by enforcing a rule on her lot that they weren't enforcing on everyone else's. I mean, it sounds like a pretty bulletproof argument on the surface, doesn't it?
That brings us to Section 3, drawing the property lines. Who owns the dirt? To really evaluate this discrimination claim, the judge had to look at the single most crucial piece of evidence in the whole dispute: who actually owns and controls the dirt. As you can see right here, the community's property definitions are incredibly complex. You don't just have your yard and the street. The land is carved up into 4 distinct zones. You've got the dwelling unit and the building envelope, which are owned and maintained by the homeowner. Then you have the common area, owned and maintained by the HOA. But look closely at that third row. The crux of this entire dispute went down in what the community calls the transitional area. This is a super quirky legal zone. It's the space right between the common area boundary and the physical walls of your house. Legally speaking, it is owned by the homeowner. It is your dirt. But according to the documents, it is strictly maintained by the homeowners association.
And this distinction is absolutely crucial when you check the community's design guidelines. The HOA essentially has absolute sole discretion over exactly how these transitional areas are landscaped. Nothing in their rules stops the association from putting down whatever ground cover they want in these specific zones, whether the homeowner likes it or not. So even though it was physically her dirt, the HOA held all the landscaping reins.
Which leads us right into Section 4, the judge's verdict. Who won the case? All right, with those complex property lines drawn, how did the judge weigh the evidence? In this kind of hearing, the homeowner had the burden of proof. She had to prove her discrimination case by a preponderance of the evidence, which, is really just a fancy legal way of saying she had to show the judge that her version of events was more than 50% likely to be true based on the facts. To meet that standard and win the case, the judge laid out a 2-step hurdle for her. Step 1, she had to first prove that a specific restriction contained in the rules was actually imposed on her.
Step 2, if she could prove that, she then had to show it was applied to her, but not applied to other owners. Pretty logical, right? Well, here is the massive twist that completely unraveled the homeowner's entire case. The judge found that the HOA didn't actually impose a restriction on the homeowner at all. I mean, let that sink in for a second. The crushed red rock wasn't a condition forced upon her as a person. The HOA merely exercised their own contractual right to landscape an area they legally controlled. Because the rock was placed in that transitional area we just talked about, they were essentially just maintaining their own controlled zone. So, the bottom line? The judge determined there was absolutely zero discrimination going on here. It completely didn't matter that some other homes didn't have the rock yet, because the HOA wasn't forcing the homeowner to do anything. They were just doing what they're legally allowed to do in a zone they have total authority over. Since she couldn't prove a restriction was placed upon her, the claim failed, and the judge officially dismissed the petition.
And finally, Section 5, Who pays the bill? Financial aftermath.
Okay, so the HOA won the battle of the Red Rocks. But wait, we definitely aren't done yet. The financial aftermath of this has one final huge surprise. Filing a petition like this is certainly not free. Because the homeowner lost the case, the judge ruled she was not getting a refund for her $550 filing fee. That is straight up money down the drain for rocks she literally didn't even want.
But honestly, the victorious HOA didn't exactly walk away thrilled either. They had to hire lawyers to defend themselves against this petition, so naturally they asked the judge to make the losing homeowner pay those really expensive attorney's fees. But they ran into a massive legal brick wall. And it all came down to how this specific type of hearing is categorized in the eyes of the law. Is it a court action or an administrative proceeding?
Here's the deal. The judge pointed to an earlier legal precedent stating that an administrative hearing just isn't formally considered a court action. Because the community rules only allow for fee reimbursement in an action, the judge's hands were completely tied. The HOA got absolutely zero legal fees reimbursed. So despite winning the case and proving they did nothing wrong, the HOA still had to foot their own giant legal bill.
This whole ordeal is a powerful and frankly really expensive reminder to always read the fine print of your community guidelines before you start a turf war over landscaping. The homeowner thought she was defending her own front yard, only to learn the hard way that owning the dirt doesn't always mean you control what goes on top of it. It leaves us with one vital question to consider about our own front yards. Do you actually know where your property lines end and your HOA's absolute discretion begins? Thanks for joining me for this explainer. I hope this sparked your curiosity, and I'll catch you next time.